Justice Mukesh R. Shah, former Judge, Supreme Court of India. Something which has always been a matter of debate, but it is something which we must remember, as the Constitution of India says. We have amidst us the highest law officer of our nation, one of our leaders, and one of the most people's person, Mr. R. Venkataramani, Attorney General for India. We also have amidst us our beloved and one of the senior most lawyers in the city of Mumbai, Shri Nitin Thakkar, President of the Bar Association, and our revered Shri Mahendra Ghelani. Since the proceedings on the other side are about to begin, may I request all of you to use the headphones, because this logistically will go on silent. May I request all of you to kindly rise for the national anthem. The Global Legal Conclave under the aegis of LIBF 2026. Lohana International Business Forum, a Section 8 organization established for the purposes of congregating business and professionals across the world, within and outside the community, together to increase the amalgam of a great concentration towards skill, business, entrepreneurial, and professional development. We have with us this morning Justice M.R. Shah, who has, despite all commitments and being one of the most busiest arbitrators in the nation, taken out time to fly in for us from Ahmedabad. Thank you very much, Justice Shah, for coming, and we all welcome you to Mumbai. We have with us Mr. R. Venkataramani, Attorney General for India, who has, out of the busiest schedule that the highest law officer in the nation would have, taken out time to bless us this morning. And I would fail in my duty to say that the old saying, behind a successful man is a lady, but behind the successful law officer of our nation is also a lady. We have with us Srimati R. Venkataramani. When we were conceptualizing the Global Legal Conclave, our revered President Satish Vithalani told me that one gentleman has lost touch with us. We must bring him back, and that is through the legal conclave. And I told him, don't worry, Nitin Bhai is the Lord Shiva of our city. He will be back with us and bless us. Thank you very much, Nitin Bhai, for accepting our invitation. it was a very, very emotional request that Satish Bhai had made, that you must be back amidst us, you must be guiding us, you are a leader of our community, and also the leader of the Bombay Bar Association. He's now on his second term as the president of the Bombay Bar Association. Thank you very much, Nitin Bhai, for accepting our invitation and being here. The last gentleman on the stage needs no introduction. Shri Mahendra Ghelani. Mahendra Bhai has been the torchbearer of the community. He has been not only steering the philanthropic causes of our community, but also the educational causes of our community. Mahendra Bhai is a revered practitioner and somebody who is really on the legal side found to be a opponent that you would not want. Thank you very much, Mahendra Bhai, to be with us. I am also very, very grateful that despite 3 parallel sessions going on, we have amidst us our president, Satish Vithalani. I must tell you one secret about him. He belongs to a nuclear part of our community, which is also Gogari Lohana, and my colleague at the trust there as my managing trustee. But when he started leading us, I was very clear that we have got the Sardar Patel of our nation back leading us. And if you even check my phone today, I have named him Sardar Satish Vithalani. He is the Iron Man of our community. He has been building this vision of LIBF was his. He has taken it brick by brick, and we're in the 4th edition. May I request Satish Bhai to come on the stage and deliver his presidential address.
Jai Jalaram to everyone. We are so honored that we have distinguished personalities in front of us, Venkataramani Sahab, M.R. Saswar, Nitin Bhai, Mahendra Bhai, and the person, behind, all hard work, the team of people, Kunal Bhai, Ganta, and Mr. Mahesh Bhai Rajpopat, So without this, it is not possible. Being Sunday, Venkataramani Sahab, that you must be finding, little less attendance. But let me tell you one thing, we are Satriyas, and, we are basically fighters. The fighter is not only with the swords, also, with, through the legal. But we are really good, whatever we do our best, So you will find best of lawyers from our community, and we are very proud of it. Sir, I'll go a little formal because I'm talking to all lawyers. Respected senior members of the legal fraternity, distinguished global advocates and solicitors, ladies and gentlemen, Jai Shri Krishna. It gives me immense pleasure to welcome all of you to the Global Advocates and Solicitors Convention at LIBF Expo 2026, Mumbai calling. The legal fraternity plays a vital role in shaping societies, protecting rights, strengthening institutions, and ensuring that progress happens within the framework of justice and ethics. In today's global and interconnected world, the role of legal professional has become even more significant, whether in international trade, cross-border investments, compliance, dispute resolutions, or governance. LIBF believes that business growth and legal integrity must go hand in hand. Platforms like this convention help us build global networks, knowledge sharing, and professional collaboration within our community and beyond. I sincerely thank each one of you for networking, but also for meaningful dialogue and long-term professional collaboration. Thank you all for being part of this important convention. Jai Jalaram. Thank you so much.
Thank you, Satish Bhai, for your torch-bearing presidential address. May I now request Shri Mahendra Ghelani to deliver his welcome address.
Everybody, we have amongst us today Krishna Bhakta also in the form of Shah Sahib, Vitoba Bhakta in the form of Mrs. Venkataramani, and therefore I'll say Jai Shri Krishna also. You have no choice but to be. Normally I prefer to speak extempore, but today I was overawed with the names of the speakers and their stature, so I have brought a prepared speech. I'll stick to it as much as I can and be as brief as I can also. Our distinguished chief guest, retired Supreme Court Justice Shri M.R. Shah, and our renowned Attorney General Shri Venkataramani, our guest of honor, eminent senior counsel and President of the Bombay Bar Association, Shri Nitin Thakkar. Incidentally, he always affectionately calls me Bhaila. Gujarati ma samjho Bhaila. He treats me as a brother and I am proud of that. Legal luminaries, fellow professionals, renowned panelists and moderators, and intellectually interested participants. Numbers doesn't count. It's your involvement and your enthusiasm, need and desire to participate in this event is more valuable. Therefore, it is wonderful to see so many bright minds getting together in this legal enclave to discuss various aspects pertaining to agility of Indian laws, architecturing the legal framework of Viksit Bharat 2047. Talking of agility, we have seen our agile President Satish Bhai, whom Kunal introduced just now. I am going a little off track, but I must mention that the agility with which he is steering our organization is something which is remarkable. I have seen Mahaparishad from 1982, and I have seen various presidents. Not because he is present here, or not because I am ever sort of a person who will polish anybody, but he is the outstanding one that we have seen, and we are lucky and proud to have him as our president. Viksit Bharat is something that we have been seeing every morning in the newspapers with our Honorable Prime Minister speaking about it and then the rest of them following. Ease of doing business, of course, is something which is of more importance for us and this enclave, because this is basically an enclave participating in a session dealing with business, commerce, industry, and internationalization of that. The blame, criticism, or some kind of a sort of reservation or innovation that the Indian business community has been experiencing is a concept or a feeling that the legal framework in India is not so conducive for a smooth functioning of businesses when it comes to some kind of either resolutions of differences and disputes or even setting up, establishing and running a business and doing compliances and so on. We are not currently dealing with the regulatory aspects and so on in this conclave. The concept of justice encompasses a very large field. And we are today to cover our discussions in the context of the legal framework, and which is why we have the stalwarts of the legal framework here to guide us and help us. justice delivery system and its effectiveness affects the business, and if it affects very considerably. Any commerce and related issues have to get somewhere or the other entangled with the administration of law. We are all aware that this subject cannot be given justice within the short time that we have at our disposal. We could have had greater advantage taken of the luminaries here, but anyway, it's not the end of time, and maybe some other time we'll be able to do a greater work, wider work. But at the same time, let us make the most of the opportunity that we have today and engage fully in the discussion of the subject. Let us discuss and exchange ideas, even have respectful debate and challenges that can lead us to the direction of broadening perspective and explore solutions to the issues to be discussed and debated. Kunal mentioned something about an opponent and an avoidable opponent. So we can have discussions, we can have debates, we can have differences also, but all ultimately leading to a conducive conclusion. I cannot think anyone here will deny, including respected Justice and the Attorney General, that the delivery system in India has collapsed. I don't think one needs to elaborate any further on that. And I'm not being very bold about mentioning this. This is a fact known to everybody and everywhere. And we all are part of the system, and we experience that every day. However, we are not here today to discuss the causes or explore the remedies to overcome the scenario, which of course is grave, of a concern for all the citizens of India. You must have read in the newspapers 2 days ago about the pendency of 36,000 cases in NCLT, and which is reported to take almost 10 years before it can be resolved. Now, this is something, a body which has been recently formed. We are not talking of the courts in India which have crores of cases pending. It's credit to the citizens of India that it has not resulted into any scenario of, I wouldn't say rebellion or a revolt, but it's something which is really, really alarming, and thanks to the endurance of the Indian citizens that they are putting up with this kind of a scenario. Not that I'm trying to incite anyone or anywhere, anything, and as I said, that's a subject which is to be separately dealt with, not here today. But we have on record retired justices of the Supreme Court and other eminent jurists who have gone on the international forums as witnesses or otherwise and have candidly admitted, either on oath or otherwise, about the failure of or shortcomings of the judicial system on account of inordinate delay and various other factors. Even when it comes to arbitration or mediations of commercial disputes between Indian and foreign entities, preference is given to the arbitrations abroad. I was just discussing, we were all discussing with Nitin Bhai about a center of arbitration being set up in Delhi by the Bar Association of India. As to why, with such a robust set of retired justices available, such a vibrant bar, that we can't have an international center of arbitration which is as active, as effective as many other elsewhere and so on, and some efforts are being made in that direction. This is connected with, therefore, the ease of doing business, that administration of justice related to businesses, etc., with the means of arbitration and mediation can be much more effective and attractive if a situation for the purpose is created. Currently, the environment has given rise to a perception in international business community so as to deal with the deficient legal redressal system discouraging commercial engagements. Where there is money, the disputes are bound to arise. Where there is business also, there are contracts, then there are interpretations of the contract, then there are implementations of the contracts, and it may not be on account of any kind of a dishonesty or any kind of uh, uh, different situations. It's a question of perceptions, and disputes and differences do arise. There may be healthy differences and disputes. There may be genuine differences and disputes. But a fair conclusion of any such disputes speedily is essential to any congenial business environment. There can't be any doubt about it. An unintended beneficial result of the delay in the administration of justice has been the preference which is being shown by the business communities and elsewhere to mediation and arbitration, despite several shortcomings experienced even in that. Fortunately, we have almost established a convention or a system that the experienced, matured, retired judges, both of the Supreme Court and the High Court, are generally being appointed as the arbitrators. This shows the faith in the impartiality and the ability of the retired judges into effective redressal of these commercial disputes. And an environment is being created to speedily resolve commercial disputes and achieve fair justice by recourse to resolve disputes by dialogue and not debate, and by conversation and not by combative confrontation. Let us hope in this enclave today, the intellectual exchange of innovative thoughts will lead us and the business community in the direction of achieving speedy commercial dispute resolution in a fair and just manner. I am sure with the participants present, the enclave will be a great success. Thank you all. Jai Mahaparishad. Jai Hind.
Thank you, Mahendra Bhai, for your special address and your sharing your valuable thoughts with us. I purposely did not use an adjective for you. The adjective was a formidable opponent. But I must tell you, what you said is absolutely correct. As much as you are a formidable opponent, you are unavoidable. And so is the pendency of the litigation or the disputes in our nation are unavoidable. But that doesn't mean that we do not have a thought process that we will delve into or bring about a thought process to reform. We have progressed as an economy, we have progressed as a nation to build something which is a system and a value that we will create through also the legal channels. The idea of getting together today is not just to have a conclave. I only call this as a start of the beginning. We are just beginning the dialogue to reformation. Each day we will evolve, we will develop, and we will build a thought process as thought leadership evolves. With these thoughts, may I request our guest of honor, Shri Nitin Bhai Thakkar, to deliver his special address.
Justice M.R. Shah, Sri R. Venkataramani, Attorney General of India, Mrs. Venkataramani, Sri Satish Vithalani, Vijay Karya, Mahendra Ghelani, Kunal Vajani, Amit Hiren, Aditya, Sri Anil Harish, respected colleagues from the legal fraternity, friends from business and professional world, ladies and gentlemen. I would begin by saying that I am a proud Lohana, a Raghuvamshi, and am feeling greatly honored to be addressing this august gathering. I must compliment Satish Bhai, Vijay Bhai, and all those who are part of Lohana International Business Forum, which I understand is since last 4 years been instrumental for creating a vital platform that has successfully connected entrepreneurs, professionals and thought leaders from all over the world. I thank LIBF for ordering me to come here today and giving me this opportunity to address. Our theme for the day, responsive laws and robust legal ecosystem, a path to Viksit Bharat 2047, represents both a promise and a challenge. As India stands 21 years away from the centenary of independence, we in the legal fraternity must confront a fundamental question: can our legal system be the engine in the current times, the bullet train of national transformation, or will it remain a constraint on our development aspirations? I am mindful that the two working sessions following this plenary session, one on the agility of Indian laws and the effectiveness of our dispute resolution mechanisms, will address the most critical questions facing. My remarks this morning are intended not to provide answers, but to frame the questions we must grapple with, keeping in mind the vision of Viksit Bharat 2047. It envisages India as a developed nation with a $30 trillion economy, inclusivity, technologically advanced and globally competitive. The numbers are indeed impressive. India is already world's third or fourth largest economy and third largest by purchasing power parity. We have doubled our per capita income, emerged as a fintech powerhouse and positioned ourselves as a global manufacturing hub. As per Stanford University, India ranks third globally in artificial intelligence competitiveness behind US and China. India has massive pool of skilled engineers and developers giving us advantage in talent availability. Yet, as we celebrate these achievements, we must acknowledge an uncomfortable truth. No nation has ever achieved sustained economic prosperity with a dysfunctional justice delivery system. The rule of law and investor confidence are not ancillary to economic growth. They are its very foundation. Consider the stark reality. Over 5.4 crore cases remaining pending across Indian courts as of January 26. More than 1.8 lakh cases have been pending for over 30 years, of which Maharashtra contributes about 1200. I saw it yesterday on the judicial clock, which is outside the High Court in Bombay. The World Justice Project's Rule of Law Index 2025 ranks India at 114 out of 143 countries in civil justice delivery. Studies estimate that judicial delays cost India more than 2% of its GDP annually, resources desperately needed for national development. These are not abstractions. Behind each statistic is a litigant denied justice because justice delayed is justice denied. A business transaction in limbo, an investment decision deferred, a pensioner waiting for his dues and a citizen's faith in the system diminished. This brings me to the two critical questions that we are seeking to address through this conclave. First, how can we make our laws more agile and responsive? And second, how can we build dispute resolution mechanisms that instill business confidence rather than fear? When it comes to the agility of Indian laws in architecting the framework for Viksit Bharat 2047, it is perhaps the most fundamental question facing our legal system today. Though we often tend to look at the bleak aspects, we must acknowledge the journey of significant legal modernization that India has embarked upon. The government has abolished over 40,000 unnecessary compliances and repealed more than 1,500 outdated laws. On July 1, 2024, we replaced our colonial era criminal justice framework with 3 indigenous laws the Bharatiya Nyaya Samhita, the Bharatiya Nagrik Suraksha Samhita, and a Bharatiya Sakshya Abhinayam. These are criminal laws represent more than symbolic decolonization. They incorporate modern evidentiary standards for digital evidence, adopt victim-centric approaches, specifically address emerging crimes like cybercrime and mob lynching, and streamline provisions from 511 sections to 358 in the substantive law. The introduction of community service as punishment reflects a progressive shift towards restorative justice. But let us be candid. Replacing colonial era laws is necessary but insufficient. True legal agility requires something far more fundamental, a systematic mechanism for periodic review and renewal of all our laws. Recently, changes in labor laws were notified. 29 central laws are being codified into 4 codes. It aims to balance increased social security for workers with improved ease of doing business through simplified, uniform regulations. At this juncture, I feel it would be worthwhile to talk about the concept of sunset clauses, provisions that require laws to justify their continued existence after a specified period. The Law Ministry has proposed incorporating sunset clauses in certain types of bills as part of its legislative reform agenda. This is a principle that has worked effectively in countries like USA, United Kingdom and Germany for over 2 decades. The logic is compelling. The laws should not be eternal. Institutional behavior and social circumstances change. A law enacted for particular conditions may become obsolete, counterproductive, or even harmful as circumstances evolve. Sunset clauses prevent legislative inertia and ensure periodic review based on contemporary needs. Take for example, TADA, a commonly act which was used for terrorist activities, which had a sunset clause and was allowed to lapse in 1995 when its utility ended. This demonstrates that sunset provisions are not theoretical, they have been successfully employed in India in specific contexts. Today we must inquire which categories of laws should have sunset clauses. What should be the review mechanism? How do we balance legal certainty with the need of adaptability? Should we mandate that all new legislation include a provision for periodic parliamentary review? Beyond sunset clauses, legal agility requires robust use of technology in lawmaking and legal processes. The e-courts mission mode project, the National Judicial Data Grid, and applications like e-Sakshya, Nyaya Setu, and e-Samand represent significant infrastructure investments. Over 99% of court complexes are now connected through high-speed networks. But technology alone is not a panacea. With a case clearance ratio in our high courts averaging just 94% in 2024, the backlog continues to grow despite digital initiatives. We need technology, yes, but we also need structural reforms in judicial capacity, procedural efficiency, development of infrastructure, and institutional accountability. We must grapple with some hard questions. How do we ensure better coordination between central and state laws to avoid regulatory confusion? How do we build mechanisms for continuous stakeholder consultation in lawmaking? How do we balance the protection of constitutional values with flexibility needed for economic innovation? How do we ensure that environmental protection and economic growth are not seen as competing objectives but as complementary imperatives? Most importantly, how do we create a culture of compliance rather than evasion, where laws are respected not because of enforcement fear but because they are perceived as fair, modern and relevant? The second aspect which requires an urgent consideration of this August conclave is how quickly and predictably can disputes be resolved in India. For international investors, evaluating where to deploy capital, the efficiency of dispute resolution is often more important than the substantive law itself. Investors can adapt to different legal regimes, but they cannot operate in environments where contracts are unenforceable, disputes drag on for years, and outcomes are unpredictable. Today, we should recount some encouraging developments and also account for some sobering challenges. There is stabilization for several jurisdictions of civil court affecting trade and commerce. Like for bank dues, we have two laws, the Recovery of Debts Due to Banks Act and SARFAESI Act. It might have disposed of in last year cases involving 8 lakh crores, but recovery has fallen to less than 10%. Secondly, NCLT. As Mahendra Bhai mentioned that there are 30,000 matters pending. The transformative impact of the Insolvency and Bankruptcy Code has one of India's most significant legal reforms. As of January 26, creditors have recovered 3.89 lakh crore through the resolution of 1194 companies, an amount representing over 170% of the liquidation value. The IBC has fundamentally altered the debtor-creditor relationship, creating a creditor threat that defaulting companies might lose ownership. Equally important, before admission into insolvency proceedings, over 28,000 cases involving 10.22 lakh crores were resolved, demonstrating that the mere threat of IBC proceedings has created a behavioral shift towards voluntary resolution. Yet challenges remain. The recovery rates have declined from 36% in financial year 23 to 27% in financial year 24. Resolution timelines have stretched to an average of 850 days, far exceeding the intended 330 days framework prescribed in the Act. The backlog, as already mentioned, is going on, and it would take 10 years to complete all the matters. So today's sessions must address these realities pragmatically. How do we balance the need for thorough resolution processes with the imperative of speed? Should we consider the pre-PEC insolvency framework for MSMEs more broadly? How do we strengthen the capacity and quality of insolvency professionals? Next is arbitration and India's aspiration to become an international arbitration hub. We must learn from global leaders. The Singapore Arbitration Center remains the most popular among the Indian parties in international arbitration. In 24, SIAC handled 625 cases, with 91% being international, involving parties from 72 jurisdictions. Indian parties consistently rank among SIAC's top 3 foreign users. Why do Indian businesses prefer Singapore over Indian arbitral institutions? The reasons are instructive. Singapore's reputation for neutrality and professionalism, its judiciary's impeccable credibility, its pro-arbitration judicial philosophy, and its efficient enforcement mechanisms. The Draft Arbitration and Conciliation Act of 2024 proposes important reforms: statutory recognition of emergency arbitrations, establishment of an appellate arbitral tribunal, enhanced role for arbitral institutions, and strict timelines for jurisdictional objections. These are steps in the right directions, but we must go further. The Supreme Court's decision in Amazon's matter affirmed that emergency arbitrator orders are enforceable in India, a progressive stance that aligns with the global practice. This session must explore how we operationalize this across the judicial system consistently. Let me share with you, Bar Association of India has decided to provide world-class infrastructure and impartial, neutral arbitrators with impeccable reputation as an alternative. So many foreign jurisdictions have shown interest, and it is a matter of time that it will present a viable, cost-effective alternative to Singapore and Dubai. The Mediation Act of 2023 provides a structural framework for institutionalizing mediation. But will it be effective, or will pre-institution mediation become merely another procedural formality that adds delay rather than resolution? like some of the social organizations have in-house mediation committees like Aga Khanis, I would strongly urge LIBF to provide a viable mediation platform for community members, community businessmen, a mediation machinery to resolve the disputes before they reach court. This conclave and its working sessions must examine these questions with brutal honesty. Are we genuinely committed to making India an arbitration destination, or are we content to see capital and cases flow to Singapore, London, and now increasingly to Dubai? What concrete steps beyond legislative amendments are needed to build institutional credibility? How do we train and certify a new generation of mediators and arbitrators who meet international standards? How do we address the challenge of government litigation, which accounts for nearly 50% of pending cases, often due to avoidable legal positions? Should government departments be incentivized to resolve disputes rather than litigate them? As we host delegates for 25 countries today in this conclave, I am reminded that legal reform is not an isolated national exercise. India's ambitious economic targets, including becoming a $7 trillion economy by 2030 and $30 to $34 trillion economy by 2047, will require massive investment, particularly in infrastructure, manufacturing, and emerging technologies. The global business community evaluates investment destinations based on the strength and predictability of legal systems. When international investors ask, why should I invest in India rather than Vietnam, Indonesia, or Mexico? The answer cannot be limited to market size or labor costs. They want to know, are contracts enforceable in India? Are disputes resolved quickly and fairly? Is the regulatory environment stable and transparent? I ardently hope that the working sessions today keep this global benchmark in mind, and we are not competing with our past performance alone. We are competing with SIAC and UK specialized commercial courts and Germany's efficiency in contract enforcement. Indian parties remain among the top 3 foreign users of these institutions abroad. This must change. India has the intellectual capital, the world-class legal talent, which is capable of deciding matters without any bias and being neutral, and constitutional framework to build world-class legal institutions. What we need is the institutional will and the sustained commitment to make it happen. Ladies and gentlemen, before I conclude, by emphasizing 3 fundamental points that should guide our deliberations today. First, legal reform is not a government project alone. It is a collective responsibility of the legislature, the judiciary, the bar, the business community, the civil society. Each stakeholder has a role and each must hold themselves accountable. We, the members of the bar, have a particular responsibility. We must embrace technology, not resist it. We must encourage early dispute resolution, not prolong litigation for commercial advantage. We must mentor young lawyers in ethical practice and efficient advocacy. And we must hold ourselves to professional standards and that enhance rather than impede the administration of justice. Bombay Bar Association, which I have the privilege to lead, is committed to partnering with the judiciary in this reform agenda. We are actively advocating for systematic improvements, provide constructive feedback on proposed reforms, and support measures that genuinely enhance access to justice. We at BBA have in last 4 to 5 years been holding regular advocacy training courses for young lawyers who are less than 5 years in practice. We regularly hold lectures in continuous education series on various subjects, inviting various professionals to address us. Agility in lawmaking and efficiency in dispute resolution are not competing objectives, but they are complementary imperatives. This conclave is commendably designed to explore these complementary dimensions. The insights you generate, the consensus you build, and the recommendations you formulate will have implications far beyond the conclave. They will inform policy debates, shape legislative proposals, and influence judicial thinking. Lastly, I am reminded of the words in our national motto Satyameva Jayate, truth alone triumphs. In the legal profession, we are the custodians of this truth. Our commitment to justice, our adherence to the rule of law, and our dedication to institutional excellence will determine whether the vision of Viksit Bharat 2047 remains an aspiration or becomes a reality. The challenge before us is not merely technical or procedural, it is fundamentally about whether we have the courage to acknowledge our shortcomings, the wisdom to learn from global best practices while respecting our unique constitutional and cultural context, and the determination to build institutions that will serve not just this generation but generations to come. The Lohana International Business Forum has created a remarkable platform for this dialogue. From Uganda to Gandhinagar to Dubai and now to Mumbai, each edition is built on the insights of the previous gathering. Today's discussions will set the agenda not just for the next conclave but for India's legal future. I am reminded of the 1950s when Lohana Mahaparishad used to hold regular conventions, and I remember my father, late Gordhanbhai Thakkar, who along with late Jayantibhai Thakkar, chartered accountant, were secretaries to the Lohana Mahaparishad Adhiveshan. I had a pleasure of attending that as a 7-year-old boy, and it left an indelible impression on me. Interestingly, they both played a pivotal role in framing the initial constitution of the Lohana Mahaparishad, which brought out all the factions of Lohanas together under one roof. And I am happy that Lohana International Business Forum and Satish Bhai in particular is now being responsible for keeping them together. And this brings our community together. And if the community is together, Vikas will also be together, achieving Sabka Saath, Sabka Vikas. I look forward to the rich deliberations that will follow, and I pledge the full support of Bombay Bar Association wherever required. Thank you. Jai Hind, Jai Bharat, Jai Lohana Parishad.
Thank you, Nitin Bhai, for the valuable thoughts that you have shared with us, the thought-provoking questions that you have raised, and the path that you have now set for the 2 working sessions to follow. I am conscious that we are running against time, and therefore, without much ado, the person that we are all very keen to hear, our blessed Attorney General for India, Shri R. Venkataramani.
If my respectful regards to Justice Shah, whom I always regard as one of the best judges who put me in tight spots when I appear before him. And that relationship continues even today. And the dignitaries here. If by birth one is not qualified to become part of the Lohana, but I suppose by affinity, then I welcome the opportunity of being called here today to address you. My brother Nitin has opened up a wide canvas. While I was listening to him with great attention, which all I think one must do when you are in conclaves like this, one hears familiar tones and familiar principles, ideas, thoughts, criticisms. So I think it's better to you look at a painter, the kind of colors a painter would like to choose. So we have in the WIPGR, blue, green, yellow, red, which prominently find a place in many paintings. Either you choose a red one or a green and a blue one. You choose a red one, everything looks so red. You have a mix of blue and green and yellow, then the painting has a different, acquires a different appeal. So I am not inclined to say that all that we keep hearing about the perils of the Indian delivery system, particularly in law and justice, are so phenomenal that one doesn't find an answer to all them, right? I wish that I would like to begin with a green color, right? Not so much of a red color. So what is the green color about? As I begin to read more and more of comparative literature on how in the past 200 to 300 years across the world, both trade and commerce, on their own initiatives, have flowered, or they required some kind of a protectionist measures from each governments. If you look at European history, way back in 1896, the then Prime Minister talks about how Germany has overtaken in England in the industrialization. So somebody in England wrote a book called The German Model, Made in Germany, the title of a book. So it's a very interesting thing to read what that made in Germany means. All that English men and women were wearing, were using, were all commodities made in Germany. Today we talk about made in China, right? Look at the global market for small things like a kitchenware, things like that. You say made in China. So we are talking about made in India, right? So I wish we write a book on made in India, and vastly different from what somebody wrote made in Germany or made in China in the past. So how do you start writing a book like Made in India? So either we have too much of protectionism, or we allow innovation and creativity to flourish. I suppose in lawmaking, we had monopolized, state has monopolized ideas and principles and thought. There's hardly any room for citizens to play a role. Therefore, the monopoly which parliament or lawmaking had been overtaken, I think there needs a window to be open. So how do you make that window to be open? I don't want to get into the question of lakhs and crores of pendencies and things like that. I think every new legal system and institution of justice, which we thought we were opening up for people to walk in and get justice, are invitations for new invitations. I suppose with a new invitation, all of us would like to write, if there is a new market open, I mean, it's a human tendency to go and see how does the new market look like. Like when Apple opens up, its markets in US, I was there one of those days. What a huge rush. So markets generally invite. So also institutions also invite people to walk in and to find out, explore how different will it be. So whether IBC code or a DRT code, etc., there were invitations to people to find out how different it will be. So by the time you stabilize, you find there are more and more people have lost their inquisitiveness about the system. They become part of a system and adding to the burdens of the system. Therefore, let's not forget that how we contribute, either as lawyers or as an institution or as citizens, we contribute to the burdens of every system. We do contribute. So when you talk about pendency, we forget about how we contribute to that system or the burdens of the system. Therefore, how do we really unlearn or to learn that the burdens we contribute can be handled by us? So we always talk about what governments can do, what institutions can do, what bureaucracy can do. I suppose we also begin to think about what we can do to unburden the burdens we impose upon the system. Now, with more than 6 years of practice in the bar, I began to become a very strong critic of the adversarial system. The adversarial system is a beautiful system. It evolved. Well, it evolved over a period of time. The Western system gave to us an adversarial system where people will combat with the best of talents, intellectual abilities and all that, and say, I am the truth giver. So the adversarial system, as many improvements you may make to the system, it will always be core content adversarial. So if you have an adversarial content, which will, therefore, whatever you may do about it, right? You have procedural refinements, you have substantive changes, and do whatever you may have, but the core content will remain always a combative content. Therefore, if you want to have as many improvements as possible, whether in the arbitration field or in the Commercial Courts Act, I think as long as we remain committed to the core content of adversarial system, we are bound to invite again and again the burdens we will necessarily put into the system. So therefore, we'll look at why we do not need to move away from an adversarial system at all, if that's possible, and why it's not possible. I think, therefore, we need to break from our deep engagement in the values of the adversarial system, while they're important because they're seemingly objective. So while we carry the seemingly objective value for an adversarial system and build something new with that, why it's not possible? It may look very wild, but I think it's possible. And I think we need to engage our minds on that. So I have been listening to a lot of talk in the past 4 or 5 years after I took over as Attorney General. Been visiting several countries and how there is responsiveness in different legal systems. I do not find, to be very frank with you, that what called the India bashing which is happening, or the India critiquing which is happening, nobody tells you what else happens in other parts of the world. Nobody really tells you what exactly is, or the ails, or the ailments in the other parts of the world, which we compare a small place like UK or a small country like Singapore, or even a Vietnam and Malaysia with India. I think it's a wrong comparison. As long as we build an environment where people's innovations, creativity in all walks of life, the first thing is, have we facilitated it? India has facilitated it. And if you don't have to go back on this facilitation. And once that environment is facilitated, then you look at other ways of what more facilitations are required. And our country requires our own country-specific facilitations. I don't think we can borrow either from Dubai or Singapore or London. You look at English arbitration law. In content is not very different from the Indian arbitration law. You look at arbitration law across the world. They all borrow same principles and methods. And you look at the pendency and some courts for instance, UK or even in Singapore, they only tell you one part of the story. The real part of the story is, given the diversities of trade and commerce and the need for innovation in our country, where the needs of our people are vastly different from the needs of other countries. Therefore, innovations, and not only in the trade and commerce field, will necessarily call for innovation in other parts of the world. So how do you therefore play a role in that? So my first meeting in 2022 as I took over was a meeting with the law minister of Singapore. So I was listening to him very carefully. Then as I began to travel across the world, recently I was in Brazil in a prosecutor general conference. What overwhelmed me was, in the conference, the prosecutor general of Brazil said, India will speak first. It was a great feeling. And why is it happening? Not because, notwithstanding all that India bashing, as they call it, we are able to stand tall in being able to promise. The promise that we are able to deliver to the rest of the world, that we are looking not only outwards, but we are also looking inwards for our own indigenous solutions. So we are talking about indigenous solutions. Of course, we can unfurl several possible legal reforms, and particularly in the field of arbitration if necessary. And we are not lacking in intelligence to be able to unfurl them. And we've been talking about the past 2 or 3 years what kind of reforms an arbitration law can have, whether we will have new arbitration tribunals, whether we have so many appellate tribunals, abolish them. These are all thought processes which will necessarily come in. I don't think one final ideal solution which we can probably place before a country to say this will solve like a panacea of all our problems. Therefore, what's important for us is to keep on moving and making, adding new chapters of a reform sector. And in that context, I think conclaves like this make a lot of sense. So I am not a cynic. I wish that none of us had become cynics, and all of us must become optimists, right? Optimism must rule our mind and our ability to tell the rest of the world that India stands tall not only in producing and making things, but in generating ideas. Now, I don't wish to be seen as what's called a cultural. People talk about too much of cultural, inputs in what we talk generally. India's spirituality, religion is a great, inheritance. And sometimes I wonder, is it really so? And what difference can it make to our legal thinking? I think there is a room for that, because as I explore myself and why we talk about, coming back to the adversarial system issue, I think it's important for us to put that aside for the time being and to explore how the diversity of needs in our community, language, religion, faith, and in the emerging. Somewhere I read that the real Marx thought that proletariats and capitalists are the great fighting issues.
But somebody said, no, perhaps a past generation of economic supporters, institutional supporters, and an emerging trend and generation of economic innovators. The conflict is between these two. I think that's true. So we must go beyond mocks and revolutions. We must go beyond that very traditional ideological configuration in looking at law. So I think once we give up all that, how do you really start thinking afresh? For law schools must become research and laboratory institutions. So we are not making them. We are making them as mere mechanical students of law. So we must start from our law schools and then our bar associations. I'm not here to give you a blueprint of all that we can do. I'm here only to share my optimism about what we can do and we can always do. I want to share that optimism. So our law schools and the bar associations and bar councils, they remain unconnected. We only meet occasionally in some conferences like this. I wish we have a bridge, a standing conference of law schools, bar associations and bar councils, where we open up our minds on, like I open up my WhatsApp every day morning. Why can't I open up on a WhatsApp, a standing conference of all these institutions every morning and share better views for our legal system? I wish we have a software which can join us together every morning and says, what is your thought for the day? And then a software will tell you what's your thought for the end of the day. I think that's how it's going. That's how I think it creates systems. Systems are not created, of course, not only by individuals who are geniuses. Systems are created by people who are being able to participate in them. Therefore, we are now lacking a participation element in our legal system. We are only either bystanders or we are victims. Why don't we become participants? And I think that's where conclaves like this make a lot of difference. And as I said, I have a lot of thoughts, a lot of ideas, but to read out like a good manifesto, take the Arbitration Act, strike out section so-and-so, have section so-and-so. I've not come here for that. I think we can do all of that. But what is important for us is to spread that feeling, what called the importance of going beyond lawmakers in the confines of parliaments and legislatures, and to understand how lawmaking can be made by the larger community. The larger community's role in lawmaking is so vital and fundamental. Last year I was in a conference where we were talking about what China has been doing in the past couple of years, the Belt and Road Initiative. They are trying to have, if you go back in point of time, when in the early 1800s, 1900s, the US railroad system, the government, the Congress gave about 200 meters, area for the railroads to build so that they can make use of the 200 meters area for it to be profitable. But then they found it was not working. Soon Congress said, I'll give you a 5 miles radius, right? That was the protectionist measure which Congress gave to the railroads in US to build. So the 5 miles radius became a great profitable venture. You could develop your railroad and sell those 5 miles radius. So these are ideas where protectionism also comes importantly. At the same time, innovation for a maker in the trade and commerce industry. What will therefore make a person innovating in commerce and industry, what would make that person comfortable? What can be given to them? What law can do in that point of giving something to them? This is where I think we are lacking. I'm not talking about the deficiency in procedural law. They'll always be there. I'm not looking at them at all. Therefore, most important to look at what can that area of comfort and ease a trade and commerce would like to have in any given dimension or of a trade and commerce. We are not looking at that. We are looking at a very general picture. Therefore, IBC or DRT, etc., came with general pictures. We need to have particular pictures. So more have particular picture, then I think law can become more and more widespread. It can become a subject-focused, institutionally focused issue. Today we are not that. Therefore, if India need to move towards 2030 or 2047, we must break forever with the past, namely in the sense of having general principles which will fit every possible question and issue. We must move towards particularized principles, particularized institutions, which will deliver a particular subject or issue. For a real estate, we had lots of, for instance, I was listening to the Supreme Court the other day, one of the judges said, only from Bombay and from Delhi we have these real estate issues. And in Gujarat, we don't have them at all. So So what does it mean? Is it a culture? Maybe there is a culture of compliance with laws. So we are looking, therefore it's important for us to look at particular areas of trade and commerce and what would suit that particular area. Why can't we develop laws and legal systems which will deliver from this angle? Then we would probably moving about unburdening. Then I think it's also important then we would not put too much burden into the system. If you are too general, burdens will necessarily come in. If you become little more focused and concentrated, burdens can be spread over. So I think that's how we must start looking at it. And I'm sure I'm certainly keen to be part of this what called an everyday conference from morning to evening with Kunal and all of you assembled here. Let us start the day saying, today we have inaugurated a WhatsApp conference, all those people who are assembled here, and say from morning to evening, our only thought and involvement is to say what I am going to do for doing something better for our legal system. If lawyers cannot invest in that thought process, I mean, what else are we here for? It's not merely to make my bank balance more, bigger. I believe that the tall persons in the legal fraternity, and I don't mean my brother like Taka, who don't care about that at all, who cares much more for delivery at the larger justice trend. So we have not been able to look at that. We're setting examples for the rest of our legal fraternity saying, the more you earn, the more important you are. I think we must put an end to that idea of the tallest man in the legal profession. The tallest man in the legal profession, I think, if you want to talk about all of this, must be those who from morning to evening think, what have I done for the system today, individually and collectively? If you don't have that idea at all, I mean, I don't know whether we can ever make any reforms. So I think, therefore, I seem to be too, talking about like a 20-year-old boy with a lot of ideas, so enthusiastic, and saying walking into the world where one does not know what traps are there. But I wish I am a 20-year-old young law student walking into the profession with the same amount of concern and excitement about what we can do. So I'm glad Kunal called me here today, the LIBF community to call me here today. And I know they would not be probably expecting this very young enthusiast talking about optimism and things like that. I think it's important for us to have it. Because I wish we stop doing India bashing. I wish we stop talking about mere pendency in the courts. And they are there in every part of the world. Let us not forget that. Sometime in mid 1930s or 40s, the US Supreme Court was talking about having an intermediate court of appeal. If US Supreme Court, with all the little work they have to do compared to the Supreme Court of India, even talking about intermediate court of appeal, what does it mean? Therefore, I think we must stop looking at the rest of the world as ideal utopian places. No, I say with great emphasis, no. India, therefore, does not. Whatever some ranking 125, 140, etc., the comparisons are all bad. Like you have a university comparison ranking, there are university ranking institutions across the globe. And what comparison do they have? So you must look at what people come into an educational institution, the diversity of people, social justice. So therefore, our ranking system across the globe have also their biases. So I would rather say the comparisons and rankings across the world on what Indian legal system is performing or not performing is a biased assessment. I don't mind saying that. I can probably dispute that also. But today is not my role to dispute that. I probably, in a year or so, I'll have a white paper where I will say India bashing is wrong for all reasons. I'm going to do that, and I want this conclave to be part of doing that. Then you will say, look here, what India can deliver. I'm once again thankful to you for your attention. Justice Shah will say many more good things for all of us, because with his experience as a judge, he knows in which direction India can go ahead. But my only thought process today is to say that capital, for capital to grow for about 300 years, it needed a certain code. That code was a code called Basic Principles of the Contract. Now, do we have a Germanic contract code which is different in basis from an English contract code? These are all superficial differences. So therefore, there are superficial differences across the globe which we're talking about. But as I said, if you are no longer a victim of the English colonial, the colonial way of looking at it, I'm sure we would be able to talk about the Indian genius. I feel fascinated about it because I am able to receive it wherever I go. I look at it as not only a student of law, but a student of sociology, economics, philosophy. So it's important for us to say that let us feel important. Let us feel important. Let us feel that we can be not only important, but being important, we can deliver. So therefore, the legal community is the only community who can walk alongside the business and trade community, say that we have common concerns, common sharing, and common outcomes that are possible. I would not like to say anything beyond that. But anyway, to conclude, I was, in the recent couple of months, I've been appearing for the Union of India in some matters, mostly concerning the mineral resources. So our mineral resources have opened up so much after the 2015 changes in the Mines and Mineral Development Law. We opened up an auction process. Like the intellectual wealth of our country, which has now opened up, right? The mineral resources opened up, and then there are a lot of private initiatives we want to hold back. We are an auction process, but those who come into the mineral industry, they want to hold back because they belong to an old generation of thinking that the regulator must not get into what we call the profit making. So we have a problem there, a tension between a regulator and the trade and commerce is. So we therefore draw a line where a trade and commerce is and being part of the Commonwealth of India. So being part of the Commonwealth of India means what? That the ease of doing business is not merely a one-sided, linear way of looking at it. The ease of doing business is part of being a Commonwealth of a country. I gave an example of mineral resources only for this reason. Therefore, other resources. If somebody is saying India ranks third in the artificial intelligence, so the question of pooling our resources in the intellectual areas, in other common areas, and areas where, for instance, if you want to go back to a 1950 picture, imagine this conclave had taken place in 1950. We would not be talking like this at all. We would be talking about what a public sector undertaking would be able to do. We're talking about that. We're talking about a regulator from a different point of view. Today's regulators are very different. They are brothers and cousins in law with those who are doing trade and business. Therefore, a different way of looking at regulation. So thank you so much for your attention. I'm sure we'll be able to march ahead with it. Thank you so much, sir.
Thank you very much, learned Attorney General. You have, at least personally for me, I can say, led up and opened up a affirmative and an optimistic path of legal thinking. Also, personally, within me, you have now given birth to an Alice in the legal wonderland. We will look forward to creating this responsive legal ecosystem together, and thank you very much. I am thanking you personally on behalf of each of us present here to welcoming all of us to be part of this daily thought-provoking exercise. Thank you very much. Our chief guest, Justice M.R. Shah, who on his last day of demitting office was addressed fondly by his Chief Justice, Mukesh Bhai, is somebody who was a judge which presided a no-nonsense court, and one courtroom where we all believed what was not necessary was face law. We got reception at all levels. We were welcomed in his court as young lawyers, as young professionals, or non-designated lawyers to address if you were ready. If you were not ready, you were out of his court. Thank you very much, Justice Shah. I know despite family commitments, family issues, you have taken out time to be with us this morning. May I request you to deliver the inaugural address.
Jai Shri Krishna. And Jai Jalaram. I only 2 days back I visited Jalaram Baba temple in Ahmedabad, and every month I am going at approximately 12:30, and where poor people are being given food. On my father's first day's anniversary, I went there. Yesterday I went there. I learned so many things from Jalaram Baba. You are the followers, all of you are the followers of Jai Jalaram Baba. And also the Krishna Bhagavan. Respected Shri Venkataramani ji, the Attorney General, dear Nitin Bhai, Mehul Bhai, all other dignitaries, Mrs. Venkataramani, my dear friend Kunal, at whose insistence and the wholehearted invitation, warm invitation, I could not say no to him. And more particularly, when I am coming from the Gujarat, being a Gujarati, when I am told that Lohana community is organizing this conclave and celebrating, so I immediately said yes. We have heard lot problems and the hope, you see, from Mahendra Bhai to Nitin Bhai to Venkataramani sir. Common voice is pendency and arrears. Number of cases are pending. I know that it is said that justice delayed is justice buried. But at the same time, I am also saying, and it is said, that justice hurried is justice buried. Our legal system, justice delivery system, is for all. Our justice delivery system is a unique justice delivery system changed from and different from the other countries with whom we are comparing ourselves. Our justice delivery system is not only for the commercial litigation only. Our justice delivery system is for common man also. With lots of hopes, people come to the court. Despite all these arrears, despite all this delay, the cases are going up. Why? Because still the people of our country have the full confidence in our justice delivery system. Whenever there is a dispute, one will say, or when there is a quarrel, one will say, court ma batavi this. Why this court ma batavi this? Because he has still the faith in the justice delivery system. And therefore he says, I'll see you in the court and a courtroom. There are problems. I entirely agree with Mahendra Bhai. I entirely agree with Nitin Bhai also that we are overburdened. But now, why there is a arrears? Why there is a delay? Now today a time has come to introspect. Why this delay has occurred? why these cases have gone up. It has not gone up, the areas has not come overnight, correct? It has come by years, from years to years to years. Sir, in one Privy Council judgment, one judge has said in those days also that we are overburdened with the cases, correct? And this system will collapse one day because of the arrears. Those were said in 1950s or earlier days also. So this is not new one, but it has increased like anything. So a day has come to introspect. And by this conclave, correct, now we will start introspecting. First thing I will like to tell that, as rightly said, that only one person, correct, is not, or the government is not responsible only, or the judges or the judiciary is not responsible for this delay and arrears. When we are talking about, when all these young lawyers and this legal fraternity is talking about arrears and delay, one has to consider who is responsible for that, who has contributed that delay and arrears. Are we ready to change ourselves? Are we ready to get out of this adjournment culture? We are not ready to change ourselves from that adjournment culture. With proud, I can say that my court was the no adjournment court. I am ready, you be ready, matter will be over and people will get the justice. When we are talking about the justice to the common man, and when I said justice hurried is justice buried, at this stage, I would like to give one example which happened in my court. The case came from Maharashtra, Bombay. 6 persons, nomadic tribe persons, were given death sentence by the trial court for the murder of some 3 or 4 persons were murdered. High Court converted 2 into life, and so far as 4 persons are concerned, it was converted, the death sentence was confirmed. Matter went to Supreme Court. Sir, SLPs were dismissed. Death sentences were confirmed. But so far as 2 other persons who were commuted to life, their life was again converted to death sentence. Review was dismissed. Curative was dismissed. Thereafter, one judgment came from the Supreme Court judgment that this death sentence should have been heard by 3-judge bench. So, the review petition was filed by one amicus curiae and from Bombay High Court. He was a great man. He was fighting for the cause. And that review application was allowed and the appeals were revived. Ultimately, the appeals came before us. At that time, I was new in the Supreme Court. And we felt that this is a case of acquittal. It was a thoroughly dishonest investigation. And the real persons were in fact given go by. And these nomadic tribe people who were moving from one place to another person, correct, against them, the case was put and then they were convicted. I was sitting with Justice Sikri and Justice Nazir. So I said that, sir, seems to be a case for acquittal. Okay, sir, brother, you are right, but ultimately, what will be our, impression in the outside? That once the SLP was dismissed, and what type of application of mind at that time when the SLP was dismissed? I said, sir, I will go for the liberty and life of a person rather than our impression or image. Then okay, you write down the judgment. Then I write down the judgment, and all the 6 were acquitted. Not only acquitted, we gave 5 lakhs compensation also, because for no reason they were there in jail for 13 years, and some further directions were issued. Why I am saying that this is our justice delivery system. Those 6 persons would not have thought in their life that one day they will be acquitted and they will be given compensation. Still, I am proud of this justice delivery system, that our justice delivery system is far, far, far better than any other justice delivery system. You go and think about China. Can you think about this such type of justice delivery system there? Can you get the justice? No. Can you get the compensation? Can you go to the court for acquisition of the land? Farmer can go? No. And still we are criticizing our justice delivery system. True, there are delay, there are errors also. But we have to find out a way. Correct? We have to find out the alternatives also. Suppose you are sick and you are taking allopathy medicine. You are not being cured. There is no improvement. What you will do? You will go to another advocate. Or you will adopt another system. This naturopathy will go, or homeopathy or go, or other things. Therefore, we have to find out the solutions rather than taking the treatment and not getting the result. Arbitration and mediation, correct, is the alternative the solution which we can adopt, and we are adopting. Government is also trying their best. Government has also tried their best also. But as a part of the society, what our Mahajan, in those days we were called Mahajan, and Nitin Bhai has said that his father, they were also part of the Shree Lohana Mahaparishad, and those days also. Those days, the family disputes or commercial disputes between the parties were frequently not going to the courts. Why? Because they were being tried to be resolved, correct, within the society, within the society itself. Mahajan was there, Panch was there, family members were there. First they were sitting together. They were trying to resolve the dispute between the parties. And then only, if after the efforts fail, then and then only people would go to court. As rightly suggested by Nitin Bhai, I entirely agree with him. The day has now come again to bring back that Mahajan system. Why can't you, correct, and the President will form a committee, have a bunch of elderly members, respectable members of the Samaj, correct, to get together and try to resolve the dispute of family dispute, matrimonial disputes, correct, and other commercial disputes within the community. Then by that, mediation also, and that thereafter arbitration also, the relations will also be maintained. In court, all of you will agree, correct, that relations will be spoiled. One of the person to the litigation will always lose and one will succeed. Whoever will win, correct, okay, he has got his result. But who will lose, he will lose the relationship. To maintain the relationship and cordial relation within the family members of the society and the Samaj, correct, a day has now come to introspect and think about bringing back the original Mahajan system. And I'm sure that this, your Samaj, that, and the Lohana Samaj, I know, they will certainly do it. They are very progressive also, correct? Though they are originally, they are fighter, but ultimately, they know how to fight against the system, the problems also, and they will do it. government has done its best to resolve the dispute, to solve the problems also. As he said that so many acts have been repealed, correct? Colonial, the acts were there. They are scrapped now. New acts have come, IPC and CRPC and the Evidence Act have changed. In Arbitration Act also and the Mediation Act also, there are amendments also, and the new acts have come. And all of are very right in coming that when there is a dispute, commercial dispute, people from outside, they don't come to invest the money. And they are fear about that once the litigation is there will be number of years will go in the court. For that also, the government and the has come with a Commercial Courts Act also. I was also part of the first commercial court when first commercial court was act came and it was resolved. And I recollect that bullet train finance was given by the Japan. And there was a dispute in the Gujarat High Court. There was a stay granted by the court. And some 1200 crores and that day, I am talking about 2005-06, they were invested by the JICA, Japan government. So the Japan Prime Minister was to come to Gujarat. And I was told that, sir, this is the problem. And there is a stay of the High Court, correct? What face we will show to the Japan Prime Minister that you are investing and still there is a litigation. That I said that I am ready to sit on Saturday, Sunday also. And if you agree, I will decide the matter. I'll go on with the matter. I sat on Saturday, Sunday also. Ultimately the matter was disposed of. The matter came to Supreme Court. Supreme Court also disposed of. Correct? What I am telling you is that we should have the persons in the judiciary with commitment to do justice. Similarly, the lawyers also, young lawyers also, should also see to it that original glory of a lawyer, correct, is coming back. Nitin bhai knows very well that, and Mahendra bhai also. Then in old days, I am talking to the young generation. In old days, what the respect was being given to the advocate or Vakil Sahib. It was said, Vakil Sahib is going. Vakil Sahib ja rahe. That was the respect which was being earned by the lawyer community, lawyer fraternity. You should get back that glory again and earn the respect. It is said, you give the respect, you earn the respect. Life is an echo. What you give, you will get back. Correct? So, you be also a part of the system. Consider it yourself to be part of the system. Correct? And then think, have the commitment to do justice. Get justice to the people. Correct? And get out of the adjournment culture. Then and then only you can talk about and criticize about the justice delivery, delay in justice delivery system. Still I believe that my justice delivery system is the best in the world. We are talking about now the Viksit Bharat in 2047. Viksit Bharat 2047 is our dream, if our goal. But we can achieve that by rule of law. Less pendency in the court. And our justice delivery system is strong. In today's conclave, there are different subjects you are discussing and you will going to discuss. Panelists, good panelists, I have seen very good panelists are there, speakers are there. They will motivate you. They will give you the proper guidance also. And these 2 days, this conclave will help our community. I am talking about first the community. Once the community is strong, correct, the nation is strong. Once the nation is strong, correct, they can get, not at present, we are third in the world economy. We would like to go to second, we would like to be first. But that can be by a strong community, strong nation, which can be done only by such conclave, such conferences. And I am happy to note, and Kunal said me, that number of delegates have come from various parts of the country, various parts of the even world also. Correct? They have participated. This shows your unity. I congratulate all the members of the Lohana community that they are united and that they will continue to be united and do the service to the society. Thank you very much for giving me this opportunity to be part of with you. Whenever I am called to serve you in any position, I will be there. I have given the standing offer to Mahendra Bhai also, to Nitin Bhai Thakkar also. Whatever I can do for your community, I will always be there. Thank you very much. Bharat Mata Ki Jai.
Thank you, Justice Shah. We are now at the close of our inaugural and the plenary session. My sincere apologies to Amit Bhai, to Mr. Kumbhakone, Farzana, and all, Anil Uncle, all of you who have been waiting for your panel discussions. Sorry, we began a little late this morning, and my sincere apologies personally on that count. May I request Mahendra Bhai to felicitate our dignitaries on the dais. Mahendra Bhai is... Justice Shah. The Attorney General. May I request my colleague Karthik to felicitate Mahendra Bhai, who has been standing as a pillar. No. Thank you very much. I will request the next session to begin. Kunal can take over and we can all leave the dais. Thank you very much.
Means either he is talking on his own without the government standing by him, or he has some support of the government. I just want to make an announcement that at my level, we have set up a working committee on sectoral law reforms, and we propose to give a report to the government in about a year's time. And while we do that, and this will be a white paper, but at a far more advanced level. And before we finally give that report, I'm sure it will be circulated widely for public consultation. And I think that's going to be one way of what called public participation in a more structured way. public consultations in rule making, etc., takes place at the government level, I thought we should widen it up. So how do you really widen it up? I'm looking at it. I'm sure this conference will enable me to look at a more wider public consultation process. Thank you so much.